Having considered the submissions by both counsels of the parties, I therefore give the judgment as follows: that after a careful consideration of the evidence before this court, it is clear that the prosecution has proven its case beyond reasonable doubt, and therefore the medical report P3 confirms that Lina, the victim in this case, a 19-year-old, was sexually assaulted and was raped. Further, the presence of Mogaka's phone, one of the accused persons in this case, at the scene places the accused persons in the room at the time of the offense corroborates the victim's testimony. And therefore, the court finds that Pato, the accused person in this case, committed the offense of rape, and that he did so in the presence of his friend Mogaka, who failed to intervene or report the crime. Accordingly, Mato is found guilty of rape and is convicted as charged, and justice demands accountability, and this court will not tolerate violence against ladies and young women. And as per this, Pato stands convicted of the offense of the rape contrary to Section 3.1 of the Sexual Offences Act, as read with Section 3.3 of the Sexual Offences Act, which prescribes a sentence of imprisonment of not less than 10 years and which may be enhanced to life imprisonment. In arriving at an appropriate sentence, this court is guided by the decision of Dismas Wafula Kikwale versus Republic, where the Court of Appeal held that a mandatory minimum sentence should not be applied mechanically, but the sentence must reflect the gravity of the offense and the circumstances of the case. The victim was 19 years old, a young lady. The offense was committed in the presence of another person, aggravating the violation and humiliation suffered by the victim. Therefore, there are no mitigating circumstances placed before this court, and accordingly, this court sentences Pato to 20 years of imprisonment to serve as a punishment, deterrence, and a clear statement that sexual violence will not be tolerated. And accordingly, Mogaka, though not principally an offender in this case, was present during the commission of the offense and failed to prevent or report the circumstance, and therefore his conduct amounts to aiding and abetting of the offense under Section 20 of the Penal Code. And therefore this court gives Mogaka a sentence of 10 years of imprisonment. The sentence shall run concurrently. It is so ordered.